This is Bloomberg Law with June Grasso from Bloomberg Radio.
A Supreme Court fight over the president's power to remove independent agency members has been teed up. On Monday, in a 7-4 decision, the U.S. Court of Appeals for the D.C. Circuit ruled that 2 independent agency members could return to their jobs while they continue to challenge President Trump's efforts to fire them. Well, it didn't take long for Trump to go to the Supreme Court with yet another emergency request, today asking the justices to allow him to immediately fire the 2, National Labor Relations Board member Gwen Wilcox and Kathy Harris, a member of the Merit Systems Protection Board. And late this afternoon, Chief Justice John Roberts signed an order pausing that ruling by the D.C. Circuit Court of Appeals and asking the 2 officials to respond to Trump's request by April 15th. My guest is an expert in this area of law, Professor Cary Coglianese, who directs the University of Pennsylvania Law School's program on regulation. Cary, start by telling us about the history of this case. What's happened in the lower courts?
Well, the lower court decided that the president does not have the power to fire the officers here at issue. And we're talking about 2 agency heads, Gwen Wilcox from the National Labor Relations Board and Kathy Harris, a member of the Merit Systems Protection Board. And the underlying statutes setting up these agencies provide that the heads of these agencies can only be removed for cause, malfeasance, misconduct, something like that. Donald Trump comes along and says, sorry, I'm firing you for no reason, really, not showing any cause. I just disagree with maybe your approach to how you want to take these agencies. That's something then that they challenged. The lower court said the president doesn't have that power because they're protected from removal at will. They can only be removed by the president for good cause. And there's a Supreme Court decision going back to 1935 that says Congress can set up independent agencies and protect them from presidents removing the heads of these agencies at will for no reason whatsoever. So that lower court decided to, though, put a hold on its order commanding that the 2 dismissed officials be reinstated to their positions. The case went up to the Court of Appeals. The panel of the Court of Appeals then was appealed further to the en banc sitting of the U.S. Court of Appeals for the District of Columbia Circuit. That's en banc means the full court. And the D.C. Circuit just issued a decision lifting the stay on the trial court's order to reinstate these officials to their position. And it did so on the similar grounds that the lower court held, that there's this 1935 decision called Humphrey's Executor that says Congress can create these good cause protections, and these officials are protected from removal with these good cause protection clauses. So the president, in firing them, acted, therefore, we're going to really force those officials back into office. They can go back and take over their positions.
The majority said that the Supreme Court has repeatedly told lower courts to follow precedents unless and until the Supreme Court changes it, referring to Humphrey's Executor there. But the dissent said in doing so, the majority threatens to send this court headlong into a clash with the executive.
Well, yeah, there's 2 issues really at stake here. One is the question that we'd say is on the merits, whether what the president did was legal and whether Congress had the constitutional power to make it illegal for a president to remove certain officials at will. So that's the question on the merits. And the District of Columbia Circuit Court here said, listen, this is like really a no-brainer from the standpoint of this Humphrey's Executor decision. It's still good law. It hasn't been overturned by the Supreme Court. We have to follow it. That's one issue. But the second issue is then, okay, once you say that the president impermissibly and illegally removed these 2 officials. What do you do about it as a court? And the dissent by Judge Rao said, there's never really been a remedy where a court has ordered officials to be reinstated in the way that the D.C. Circuit now has said the district court could do. The Humphreys Executor case from 1935, for example, rose in a dispute over a claim for back wages. The court there said, okay, that was illegal to remove what was then a member of the Federal Trade Commission improperly for no reason, and the member's actually estate was entitled to back wages. This is totally different, Judge Rao says. This is totally different. Here we have now a court ordering that officials who have been purportedly fired by the president, maybe illegally under current law, but while this litigation is pending, shouldn't we just, she says, keep things on hold and not force the issue of reinstating these two officials and get this up to the Supreme Court and let them decide. And if at that point in time the Supreme Court decides that the president acted illegally, then the Supreme Court can decide whether it's an appropriate remedy to force these folks back into their positions. But right now, it is certainly setting up a real confrontation between an order from a lower court judge and a president's order to fire these folks. Which one prevails? I think it's very clear and quite certain that the Supreme Court is going to step into this matter, and we will see what they do, probably on the remedies front pretty soon, and then the question is, how long they'll take to decide the merits.
The Solicitor General said it intends to ask the Supreme Court to overturn Humphrey's executor, and that's a decision that conservatives have been dying to get overturned for years. Do you think it's on the chopping block?
Yeah, I think it is certainly going to be, in all probability modified, if not overturned entirely. The Supreme Court has really for the last 15 years been cabining the scope of Humphrey's executor through a number of decisions. In one case saying that you couldn't have a double layer of officials who have this good cause protection. That was a decision in 2010, and then in 2021, the court said, well, you can't have a single-headed agency with good cause protection. It's fine still for these commissions or these boards that have multi-members. Humphrey's executor still stands for those, but not for agencies headed with just one person. The question is, though, if Humphrey's executor does go, what happens to the Federal Reserve, which I don't know the Supreme Court, and quite frankly, this administration right now is saying that monetary policy still can be kept independent. We'll see how long the administration takes that position, but I think the Supreme Court's going to be certainly cognizant of what it could do to the economy if the Federal Reserve Board loses its independence. And the second issue is, well, if Humphrey's executor goes, what will happen to the protections for the civil service and its independence? Maybe there's some ways that the court could, in overturning Humphrey's executor, create a carve-out for the Federal Reserve. Probably easier to see how it could still keep the civil service protections intact, but we're just, really getting close to restructuring some, fundamental aspects of U.S. government that we've had in place for nearly, 90 years now.
I mean, what does it say that the appeals court voted 7-4, the 7 Democratic appointees blocking the firing, and the 4 Republican appointees, including 3 Trump appointees, giving a go-ahead to the firing?
Listen, there's no question that these structural questions of administrative governance have taken on a high level of ideological salience, and it's certainly reflective in the judiciary as it is in the polity at large. So, we definitely have a good number of folks who have, on the political right, been trumpeting the unitary executive theory now for several decades, and this is sort of the logical extension, and maybe even some might say the last vestiges of a holdout on the unitary executive theory. And I think it has some real consequences, and I think this is what those who are concerned with how far the court might go if it does modify or ultimately overturn Humphreys altogether. I mean, as I said, there's real concerns about what it would do to the central bank's independence, and there's an awful lot of really extensive economic research that shows that countries that have central bank independence do better economically, that's an important thing to protect and preserve and not have monetary policy interest rates being dictated by what might be in the short-term political interests of somebody in the White House, of either party. And there's also concern about, political control, presidents having too much control over agencies like the Federal Communications Commission and having power to make decisions that might be reflective of their own political interests. There's the Federal Elections Commission. Some of these agencies are ones that really wield a considerable amount of power, and power that can be directly relevant to somebody who's a politician and wants to stay in office and use these powers not for the good of the country, but for the good of staying in office. And that's what's, I think, at stake with this litigation here. And quite frankly, there's other lawsuits also pending with other officials of independent agencies who President Trump has fired at will. So this is going to the Supreme Court. It will be a blockbuster decision when it comes out, and we'll have to see what kind of waves it makes for the country and the future of its governance. Is it going to be just some heavy waves that we can navigate, or are we unleashing a tsunami for the country where a president can now wield control over some really important government agencies? The president acting as if Humphrey's executor has already been overturned. I mean, they've taken the position that, as you indicated, they're going to argue in court Humphrey's executor should be overturned. But in the meantime, the president has also issued an executive order that says, listen, I'm going to subject all you independent agencies to White House review of your regulations, White House review of your budgets, Department of Justice review of your legal opinions and positions. We want to have a say over your strategic planning. This is all now happening, and it's unprecedented, really. There's never been an administration that has acted as if these independent agencies are no longer independent. And it's in progress. These agencies are submitting their work for review by the White House, and we're already in a world in which there's an incredible degree of White House involvement to a level we've never seen before. The only question is just whether, at the end of the day, the president's going to be right that if there is some conflict ever between the view of somebody at the head of one of these agencies and the White House can legally fire him. Right now, that's unclear. But like I said, the administration's taking that position, and in this case and others, gone ahead and made those firings anyway.
It seems like another big case at the Supreme Court. Thanks so much, Cary. That's Professor Cary Coglianese of the University of Pennsylvania Law School. Coming up next, the Justice Department shuts down its cryptocurrency fraud unit. This is Bloomberg. The Justice Department is scaling back its cryptocurrency crime investigations to focus on cases related to terrorism, drug cartels, victimizing investors, and other specific categories. The department will no longer target virtual currency exchanges, mixing and tumbling services, and offline wallets for unintentional violations of regulations. and will also close existing investigations that don't align with its new priorities. Joining me is an expert in securities law, Jon-Jorge Aras of Aras Law. So tell us about this memo from Deputy Attorney General Todd Blanche about scaling back cryptocurrency enforcement.
Todd Blanche and the Department of Justice have taken a step away now from focusing on crypto enforcement, which was a primary target of the Biden administration. And they've essentially said, listen, the Department of Justice, we're not going to have this crypto task force anymore. We're not looking at crypto as a key area. We're refocusing to issues like immigration, issues dealing with fentanyl, human trafficking, and that for now, our priority is not looking at crypto that's created or how its end users may take the product and then use it for something illegal. They're still looking at fraud, obviously, on a more broad level, or if any of crypto ends up being used for something that fell into those categories, let's say, illegal human trafficking or something like that. But it's really been a big step by the government across the board, SEC included, and the Department of Justice, to now take a step back and say crypto is not something that we really even have a regulatory framework for at this time. So it feels like a hands-off approach.
How could this affect, the average consumer?
I think it's a buyer beware market now for crypto. I think it's safe to assume that any company that's based in crypto or any individuals that are trying to start a new crypto-based business or launch a coin, whatever it may be, fraud is still fraud, right? Lying about something to induce an investment and taking that money and misappropriating it or using it for themselves. I think that's still on the table and something that could potentially be looked at. It'll be consumer driven, right? People complaining, people filing their own lawsuits through their attorneys, going after it. It does feel, however, though, that they're not going to approach this in a way anymore where they're saying, hey, this is securities fraud. Crypto is a security. We know there was that huge case with Coinbase where the SEC dropped its enforcement action against them on the basis that Coinbase had challenged what they were engaged in was not securities, that crypto aren't in fact fit the definition of a security. So without a regulatory framework of where to box this into, what this digital asset actually is, fraud is fraud, wire fraud is fraud, mail fraud is fraud. However, that applies to everything, right, across the board, every single industry, and crypto is no longer getting that special treatment or that more intense look just because it's crypto. So it's a more broad approach. Crypto by itself doesn't raise a red flag anymore, which I think has really freed up this industry. Not that long ago, under the Biden administration, crypto was under a heavy, heavy attack across the board, whether it was the SEC or the Department of Justice. That has all really been unwound, and it's at the behest of Donald Trump, who is approaching his administration from a very, very friendly crypto point of view.
He's also issued his own crypto token just before taking office.
I think that was a big indicator of where regulation was going to head. And that caught a ton of people by surprise, myself included, but just following across the industry, that it was sort of the silent launch of this, I guess what's dubbed as technically a meme coin or just this token, that it was just the Donald Trump token, as simple as that. And he launched it. So I think that was an early indicator for us and for the public at large that crypto industry was going to be given much broader latitude than it had been, because things were getting really narrow. And if it was determined that the crypto industry was subject to the regulatory framework of the securities and exchange industry, that changes everything, right? That changes the barriers to entry. That changes every aspect of that business and how they would deal with launching a coin, what exceptions they would have to fit into, whether they would need to be registered with the Securities and Exchange Commission. It's very complex. So now I know people throw this term around a lot, but, are we in the Wild West of crypto when it comes to regulation? I'd say yes.
And the person he's chosen to lead the SEC has substantial investments in crypto.
Yes, this is an administration now that's saying crypto is its own asset class. The SEC has put together a team that's looking at a proposed framework for what would go around this, right? What rules and regulations would they have to have in place? Right now we have anti-money laundering rules. We have FinCEN. We have very basic money service businesses that you can be registered with FinCEN and be regulated by the government. But we don't have anything that's directly on point saying, okay, you're selling a crypto, you're issuing a new crypto to the public, you have to abide by these set of rules. So I think the way that they're going to approach it is, I would say, securities light at some point. If they do issue their regulations or proposed regulations around this, they're really, in my opinion, going to take a less stringent approach, which, I don't know, may or may not be good for consumers. It may fall into the hands of plaintiffs' attorneys, if there is fraud, to go after it through the courts on their own. And I think that was kind of the message from the SEC and the Department of Justice. They're not going to put a big enforcement focus on this anymore.
Do you think that the states will step in? Some states have said that they are going to step in.
I think it's tough. They could be preempted by federal law, but obviously there's no law on the books right now. If a state is not against crypto, but is skeptical of it or wants to put some rules around it, they could. It's quite complex, and there's arguments against it too. I mean, it's the free run of capital. It's allowing people to invest or put their money into a new asset class that we've seen can generate extraordinary wealth. People could lose all their money. Some states, I think, will be even more crypto-friendly and try to attract that business to them. The ones that regulate against it may be missing out on those opportunities, although I can see in some instances them stepping in. But broadly, right, across the United States, we've seen things that were once highly regulated and illegal are now flowing free. For example, the cannabis industry, right? We have a lot of legalization. And also with sports betting, there's been widespread legalization of it. So states view this as a potential to generate new tax revenue to support other projects. Without federal regulations on top of this, states could create an attractive environment for crypto businesses to set up there as opposed to limiting that.
I mean, do you think that cases like that against Sam Bankman-Fried would still be discovered and go forward, or they might be missed?
I think they'll likely be missed. I could say that, personally, I work as a defense attorney in the white-collar civil/criminal space with a specific focus on securities. And I've had investigations where I've represented individuals related to crypto, right, in one way or another. And during the Biden administration, there were a lot of inquiries. There were a lot of subpoenas. There was a lot of trying to figure out what was really going on in this industry. I can tell you that at the tail end of that administration and into President Trump administration, it has been completely silent on ongoing investigations. So from my perspective, I don't think it will be looked into. I don't think they're going to issue subpoenas. I don't think that they're going to be investigating it in the same way. And you bring up something interesting with Sam Bankman-Fried. Who knows? Maybe his sentence may be commuted, He may be put in a position where he gets out of jail much sooner in light of these very recent changes. And we have a precedent for this. There was Ross Ulbricht, who was the founder of Silk Road, which was sort of the first, exchange, for lack of a better word, where you could utilize crypto to buy anything, on the internet or on the dark web. And he was sentenced to, I think, 2 lifetimes in prison, like 200 years. And when Trump got into office, he pardoned him right away. He has been in jail for 10 years, and now Ross Ulbricht is free. So I think in regards to your question, it may even go one step further. Not only will these not be investigated, these type of crypto-based frauds, we may see people that have been prosecuted for them, like SBF, get a reduced sentence and be set free.
Before I let you go, do you think any of the cases you were handling that seemed to have stopped could be started up again?
in my work, I've had really intense investigations with the Department of Justice dealing with hundreds of millions of dollars related to various crypto frauds that were out there that completely stopped. I never got another follow-up call again. The investigations are, from what I understand, done. They don't send a closing letter, but they're done. So I think it really has changed. I was just speaking to a friend of mine who's in the crypto industry, and it's like a green light for any project they want to run. The only thing you have to watch out for is, anti-money laundering, really just making sure that the money that you're getting is from real people and not, from some illicit scam.
It all seems to be evolving very quickly. Thanks so much for joining me on the show. That's Jon-Jorge Aras of Aras Law. Coming up next on the Bloomberg Law Show, the Justice Department suspended 2 lawyers involved in the high-profile case of a man deported to an El Salvador prison because of an administrative error. A case that illustrates the position government attorneys can now find themselves in while facing the dual demands of loyalty to the Trump administration and candor to the courts. The Trump administration is facing a barrage of lawsuits challenging President Trump's executive orders, some of which have already led to judges grilling Justice Department lawyers who are defending their legal basis. The suspension of 2 Justice Department lawyers in a high-profile deportation case illustrates the position government attorneys can find themselves in while facing the dual demands of loyalty to the Trump administration and candor to the court. Joining me is Bloomberg Law reporter Justin Wise. Justin, the most high-profile cases so far are those that involve the deportations of alleged Venezuelan gang members to prison in El Salvador. And one case involves a legal challenge by Abrego Garcia over his removal to a prison in El Salvador, where the government has admitted that he was sent there. Tell us what happened at the April 4th hearing before a Maryland federal judge.
Sure. So, like you said, this is a case that involves instance where the U.S. has admitted that they made a mistake in including a Maryland resident on a flight for alleged gang members to an El Salvadoran prison. During that hearing, the judge was pressing the U.S. as to why the U.S. position was that it could not return this person to the U.S. In response, the lawyer for the Justice Department representing the government said basically that when the case landed on his desk, the first thing he did was ask his clients that very question, that if they made that mistake, why the U.S. was not able to return him, and that he'd yet to receive an answer that he found, quote, satisfactory, and that he also conceded that the U.S. had mistakenly deported this man to El Salvador.
So how long did it take before he and his boss were suspended?
It was the day after. So the hearing was on April 4th. By April 5th, over the weekend, we had reported that he and his boss were put on leave. Some of the reasons, the exact specific reasons surrounding their suspension are not totally clear, but in response to inquiry about them, Attorney General Pam Bondi did release a statement saying that all attorneys at her direction must zealously advocate for the U.S. and that those who fail to will, quote, face consequences.
There are concerns about the kind of precedent this sets to suspend a lawyer for telling the truth in court. That's what lawyers are supposed to do.
Right. I mean, it kind of gets to this idea of zealous advocacy. When Attorney General Pam Bondi first arrived at the Justice Department, she issued this memo that kind of spelled out her expectations of the DOJ's lawyers in regards to zealous advocacy on behalf of the president and on behalf of the administration. And while vigorous advocacy on behalf of a client is a core component of the legal system, legal ethics experts and other lawyers I've spoken to as well have brought up how the obligations are, balanced by a lawyer's other duties, namely exercising professional judgment and, of course, being truthful to the court.
And there have been several instances of exchanges between judges and DOJ lawyers where either the DOJ lawyer couldn't give the judge the information he or she was asking for, or there was a conflict. Can you tell us about some of those?
Right. Yes. This is by no means an isolated instance. So the Justice Department defends the administration in litigation, and that means lawyers are being put in the position of answering for a number of the executive orders from the Trump administration that are subject to litigation. And judges have, in a lot of different scenarios, been skeptical and grilled lawyers over the certain orders, whether it's related to birthright citizenship or an order that was barring transgender persons from the military, as well as litigation involving Elon Musk's actual role in the government efficiency effort. A judge had told a lawyer that, the answers he was getting were, quote, highly suspicious. So, this episode kind of speaks to the position a lot of lawyers are in right now as they try to defend the legal basis of a lot of these actions in the face of really pressing questions from judges who are deliberating over the legality of these orders.
Have any of the attorneys been sanctioned by judges to date?
No, not to date. There has been no instance in which an attorney has been sanctioned. That has yet to come into play here. D.C.
Federal Judge James Boasberg was and perhaps still is considering a contempt order in the case where the Justice Department did not obey his orders to turn two planes around carrying hundreds of Venezuelan deportees. We'll see if he goes forward with that, despite the fact that a Supreme Court decision has said that those cases have to be challenged in the jurisdictions where the detainees are located. These kind of moves by the Justice Department, suspending lawyers who are being candid with judges, could damage the Justice Department's reputation as well as hurt the credibility of government lawyers.
Right. I spoke with a lawyer who once trained DOJ attorneys on some of these professional responsibility issues. And, the idea is that when a lawyer is speaking before the court, there's a lot of deference that judges are giving lawyers, especially those representing the government. And the question becomes, if the courts begin to have some skepticism about the answers, more skepticism about the answers they're getting from the government, what's that mean for how they, deliberate and weigh in on the cases they're considering?
Can state bars do anything in this regard?
So as I understand, just like how courts can get involved on this and perhaps issue sanctions, state bars can get involved and choose to respond. I know that just through, the normal course of litigation and lawyering, really, that complaints are filed to state bars as well for a certain government official or private lawyer, that those things are common practice in the legal industry. So I do know that state bars certainly can. As far as whether they will or anything that we can learn about them, those things are normally tightly guarded and don't come out publicly until maybe a decision is reached and when that decision actually involves the sanctioning of a lawyer. So the details around that are a bit hazy.
Tell me about the person who launched a group to support DOJ employees.
That's right. So Stacey Young, a longtime DOJ lawyer and alum of the Civil and Civil Rights Divisions. She spent nearly 2 decades inside the Justice Department. She resigned in January and launched a group called Justice Connection, which, as she has said, is designed to offer support for DOJ employees amid a time of massive upheaval inside the department. In addition, it's clear that she's using her role leading this group as a way to speak out about some of the things going on inside the administration and inside particularly the Justice Department and the ways in which it's shifting under Trump.
It seems like these lawyers, to use an old expression, are stuck between a rock and a hard place as they go into court. Thanks so much, Justin. That's Bloomberg Law reporter Justin Wise. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.